Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we start with a new topic, that is the Indian Evidence Act. We will be dealing with all the important questions relating to the Indian Evidence Act in 2 lectures. Today is our first lecture and then we will be having one more lecture on the same subject, right? So I have been stressing on this point that security laws, they form a very important part of your syllabus, but at the same time you have to remember that criminal law is also important. So we have done CRPC lectures and now we start with the Indian Evidence Act, which also forms a very important part of your syllabus for both descriptive and objective part. So please make sure that you are careful when you are preparing for the same. Right, let's start. Before I start, I would like to tell you that EduTap has come up with 2 courses, the first one being the test series and other one being the live crash course. The test series for the phase 2 examination includes chapter wise test, which means you get test for each of the chapter that has been mentioned in your act, which has been mentioned in your syllabus. So for each chapter, for example in IPC, in CRPC, you get separate test which you can practice. The second feature includes full-length tests with evaluation. So as descriptive part has been introduced for the first time, it will be very helpful for you. Our experts are going to evaluate your answers and give you necessary feedback, which is going to be very helpful for your preparation. So please make sure that you avail it, right? And also you get one-on-one mentor support. At the same time, we also have a live crash course and the live classes, they are already going on, and the classes which have already been conducted, you get the recorded sessions of that. So that means even today you can buy this course and you can start your preparation. It is going to be very helpful for you. Plus you get short notes for your descriptive part. It will be very helpful. You can take the help of these short notes and prepare your descriptive portion, right? And all the features of the test series, they are also included in the live crash course. So for your revision, it is going to be very helpful, and you also get one-on-one mentor support. So we are running a limited time period offer. If you want to avail it, you can refer to the link in the description below. Now let's start with our lecture. Question number 1. Indian Evidence Act was drafted by. So the right answer is option B, that is Sir James F. Stephen, right? So it is answer B. The Indian Evidence Act introduced a standard set of laws applicable to all Indians. The law is mainly based upon the firm work by Sir James F. Stephen, who could be called the founding father of this comprehensive piece of legislation. Question number 2. The law of evidence consists of ordinary rules of reasoning, legal rules of evidence, rules of logic, rule of law, or all the above. The answer is B, that is legal rule of evidence, right? Something will be accepted as evidence by the court if it is admissible as evidence in legal proceedings. There are 2 factors, relevance and admissibility. So you have to remember that both these terms, relevance and admissibility, they are different. Something which may be relevant may not be admissible in the court. Relevance, it is based on logic. That something that is logical, it should be relevant. But according to the Indian Evidence Act, not all logical things are made relevant here, right? Here in Indian Evidence Act, we have legal relevancy. Only those things are made legal, only those things are made relevant which is included in the Indian Evidence Act. That is why something which is relevant may not be admissible in the court of law according to the Indian Evidence Act, right? So the expression relevancy and admissibility are often taken to be synonym, but they are not the same. All admissible evidence is relevant, but all relevant evidence is not admissible. This is what I have told you. Relevancy is the genus of which admissibility is the species. Question number 3. Law of evidence is, so the answer to this question is option B, that is lex fori. Law of evidence is lex fori. It means evidence is one of those matters which are governed by the law of the country in which the proceedings takes place, that is lex fori. The Indian Evidence Act 1872 came into force on 1st September 1872. Question number 4. Under the Evidence Act, fact means factum probandum, factum probans, both, probandum, none of the above. So the answer is option C, that is both factum probandum and factum probans. You should know that what these terms means because it is important for your syllabus, right? So what is factum probandum and what is factum probans? Factum probandum refers to the ultimate fact to be proven. So something which we have to prove in the court, that is known as factum probandum, and through the means of factum probans we prove the factum probandum, that is the evidentiary facts which we use to prove the main fact in issue, that is known as what? That is known as factum probans. Let's read this. Factum probandum refers to the ultimate fact to be proven or the proposition to be established, that which a party wants to prove to the court. Factum probans refers to the evidentiary facts by which the factum probandum will be proved, right? So this is an important question. Please make sure that you know this. Question number 5. Evidence under the Indian Evidence Act means and includes. So the answer to this question is C, ocular and documentary evidence both. Evidence means and includes, so it is an inclusive definition, all statements which the court permits or requires to be made before it by witness in relation to matters of fact under inquiry. Such statements are called oral evidence. All documents including electronic records produced for the inspection of the court, such documents are called documentary evidence. So Indian Evidence Act, it includes both ocular, that is oral, and documentary evidence. Question number 6. Communication in respect of the affairs of the state are privileged communication on the grounds of public policy under. So the answer to this question is option A, that is it is given in section 123 of Indian Evidence Act. Section 123 Indian Evidence Act states no one shall be permitted. So here no one shall be permitted. You are not being permitted. You will not be given the permission. If someone even wants to do it, they cannot do it, right? So no one shall be permitted to give any evidence derived from unpublished official records. Something that is unpublished, that is not made public, right? So derived from unpublished evidence derived from unpublished official records relating to any affairs of the state, except with the permission of the officer at the head of the department concerned, who shall give or withhold such permission as he thinks fit. So if you want to give such an evidence, in that case what you need permission of the head of that department. If he permits, then you can present that evidence, otherwise you cannot, right? So this is no one shall be permitted to give any evidence derived from the unpublished official records. Something which is not made public, you cannot use it in the court for evidence, right? For example, it can be documents relating to the intelligence bureau, relating to the defense. So these documents, they cannot be used as evidence in the court of law. This section is based on a maxim called Salus populi est suprema lex, which means public welfare is the highest law, right? So this is based on Salus populi est suprema lex. Alright, moving on, question number 7. Alibi is governed by. So this we already know that this is section number 11 of the Indian Evidence Act, alibi, right? Let's read this section also. Facts not otherwise relevant. So these facts, they are not otherwise relevant, but they are made relevant here. How they are made relevant? Let's see. Facts not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant fact. They are inconsistent with any fact in issue or relevant fact. So if they are inconsistent, if they are completely inconsistent with the fact in issue or a relevant fact, then those facts, they are made what? They are made relevant here. For example, if we take the example of alibi, there is a person A who wants to prove that I was in Calcutta at 12 p.m. and that is why I could not have possibly murdered B, who was in Delhi at 12 p.m., right? Who was murdered in Delhi. So the fact that he was in Calcutta at 12 p.m., it is not relevant otherwise, but it is made relevant here. How? Because it is inconsistent with the fact that he was not in Delhi. So it is inconsistent. The fact proving that he was in Delhi, it is inconsistent with this fact. That is why this is made relevant. So this is what? This is alibi. He is proving that I was at some other place, right? So this is completely inconsistent. Either it is black or white. Inconsistent implies that it is impossible, right? Either it is black or it is white. So this is inconsistent, that he could not possibly have been in Delhi because he has proved that he was actually in Calcutta at 12 p.m. If by themselves or in connection with other facts, they make the existence or non-existence of any fact in issue or relevant fact, highly probable or improbable. Firstly, we talked about the inconsistency, right? But now they are talking about something which makes something probable or improbable. For example, let's just say that A was seen with B at 2 a.m. and then B's dead body was found at 2:30. So this is highly probable that A must know that how B has died. This is what? This is something which is highly probable. This is probable. This is not inconsistent with the fact, but this is something which could have happened, which could be true, right? So let's read this one again. If by themselves or in connection with the other facts they make the existence or non-existence of any fact and issue or relevant fact highly probable or improbable, right? Illustration, the question is whether A committed a crime at Calcutta on a certain day. The fact that on that day A was at Lahore is relevant. The fact that near the time when the crime was committed, A was at distance from the place where it was committed, which could render it highly improbable, though not impossible, that he committed it is relevant, right? So this we have done, that he was in Calcutta and that is why he could not have murdered someone who was in Delhi, right? So I hope you are clear with this question also. Moving on, question number 9. Admissions. Answer is C. Either they can be oral or in writing, right? So before starting with the topic of admissions, you should know that statements are a genus, admissions are species, and confessions, they are subspecies, right? If I am stating something, all that I am saying right now, I am stating something, this is what? This is a statement, right? I am making what? I am making statement. So the maker of the statement will not say something which is against his own interest, right? It is presumed that the maker of the statement is not going to state something which is against his interest, and if he is doing so, in that case it must be true. So this is the basis of the admissions and confessions, right? In Indian Evidence Act, they are divided. Admissions and confessions, they have been divided into criminal and civil. So the admissions, they relate to the category of civil law, and confessions, they relate to the category of criminal law. It is evident from the fact that the sections mentioning the confession, they relate to the police or they relate to the custody. The words used there are police officer, the custody, the police custody. That is why this is said that the confessions, they relate to the criminal law and admissions relate to the civil law in Indian Evidence Act, right? So let's read this. Section 17. An admission is a statement. It can be oral, it can be documentary or contained in electronic form. All are possible, which suggest any inference, okay? Which suggest what? Which suggest any inference as to any fact and issue or relevant fact, and which is made by any of the persons and under the circumstances herein mentioned. So admission, they are inferences which are made in relation to the fact and issue or a relevant fact, right? Moving on, question number 10. A confession made to a police officer is inadmissible under, the answer is B, that is section 25. Confession to the police officer not to be proved. No confession made to a police officer shall be proved as against a person accused of any offence. So when I was talking about the admissibility and relevancy, this comes into play. For example, now you know that if a person is confessing to a police officer, it is a relevant fact. If you think otherwise, it is a relevant fact, but this is made inadmissible under Indian Evidence Act, right? So that is why I was telling you that in Indian Evidence Act, we deal with the legal relevancy. Only those things are made relevant which are provided herein, that is in the act, right? So no confession made to a police officer shall be proved as against a person accused of any offence. So a police officer could be any police officer. He could not even be your investigating officer. He could not even be a police officer of the station where your case is pending. Or it could be that an FIR has not been registered. Or it could be that you are not even an accused. In that case also, anything said to a police officer, any confession made to a police officer is inadmissible. We cannot prove it in the court of law, right? So no confession made to a police officer shall be proved as against a person accused of any offence. This is section number 25. Question number 11. Under which provisions of law can a court direct any person to write any words or figures for comparison of handwriting? So this is section 73, that is option D, 73 of Evidence Act. Comparison of signature, writing or seal with others with others admitted or proved. So this is just one way of proving handwriting. There are many other ways. For example, asking the person who has actually made that writing, or asking the testator, asking the expert. So this is just one of the options that are available. In order to ascertain whether a signature, writing or a seal is that of the person by whom it purports to have been written or made, any signature, writing or seal admitted or proved to the satisfaction of the court to have been written or made by the person may be compared with the one which is to be proved, although the signature, writing or seal has not been produced or proved for any other purpose. So what this section is saying, that if you want to prove a handwriting, for example, you can do what? You can just compare it with an undisputed handwriting of the same person, right? If you know that handwriting belongs to that person only and it is undisputed fact, in that case the court can do what? The court can compare such handwritings. This is applicable to the handwriting, signature, seals, right? The court may direct any person in the courts to write any words or figures for the purpose of enabling the court to compare the words or figures so written with any words or figures alleged to have been written by such person. This section applies also with any necessary modification to finger impressions. This could be asked, that section 73, this also implies to the finger impressions also, right? So this is just a way of comparing the handwritings and proving it, right? Moving on, question number 12. Which of the following is not a public document? The answer to this is option A, an unregistered family settlement. So what is a public document? A public document is a document which is made by a public officer. It is kept in his custody. It is made for the public and it is made for decades and decades to come. That is, it is made for the time immemorial, right? So this is a public document. So a public document, the following documents are public documents. Documents forming the acts or records of the acts of the sovereign authority, of the official bodies and the tribunals, and of the public officers, legislative, judicial or executive, for any part of India or the Commonwealth or for a foreign country, right? So they also include the foreign country. The public documents also include the foreign country. Public records kept in any state of private documents. So the public records of the private documents, they are also what? They are also public documents. Question number 13. Which of the following statements holds true for dying declaration? The answer is option D. When eyewitness affirms that the deceased was in a fit state to make the declaration, medical opinion cannot prevail. Let's read this section. This is section number 32. Statements written or verbal. So they can be written, they can be verbal, of relevant facts made by a person who is dead. So who is dead, it is made by that person, or who cannot be found, or who becomes incapable of giving evidence, or whose attendance cannot be produced without an amount of delay or expense, which under the circumstances of the case appears to the court unreasonable, are themselves relevant facts in the following cases. So they are made relevant in the following cases. So this is actually due to the principle of necessity. Why? Because according to the natural justice principle, one person who cannot be cross-examined, who cannot come to the court, who cannot cross-examine his statement, it should not be used in the court of law. But someone who is dead or someone who cannot be found, in that case, what do? We have to use that evidence, we have to use that statement which is necessary for that case. So that is why, invoking the principle of necessity, it is made relevant here. Something, a statement made by a person who, for example, is dead, who cannot now come to the court and be cross-examined, his statement is made relevant, it is made admissible in the court, right? So statements, oral or verbal, of relevant facts made by a person who is dead or who cannot be found, or who has become incapable of giving evidence, for example, due to any incapacity, it can be due to age, it can be medical reasons, or whose attendance cannot be produced without an amount of delay or expenses, which is under the circumstances of the case appears to the court unreasonable, are themselves relevant facts in the following cases when it relates to the cause of death. When the statement is made by a person as to the cause of his death. When the person, he made that statement, he was dying and he told about what? He told about his own death. He told about the reason of his death. So when the statement is made by the person as to the cause of his death, or as to any of the circumstances of the transaction which resulted in his death, in case in which the cause of that person's death comes into question. Basically, a statement made by a dying person, that is a dying declaration made by a person person who was dying, but it has to relate to what? It has to relate to his own death. If a dying person, before he died, if he made a statement about the reasons of death of any other person, that is not admissible, right? It has to be for the reason of his own death. So when the statement is made by the person as to the cause of his death, or as to the circumstances or how that happened, the transaction, he referred to that, or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of the person's death comes into question. In any case in which the reason of such death it comes in question, in that case that statement made by the dying person, it is going to be what? It is going to be admissible in Indian Evidence Act. But there arises one question: what if a person who made that dying declaration, who made that statement, actually survives? In that case, will his statement be discarded? The answer is no. Now that he has survived, he can come to the court, he can be cross-examined now. So his statement, it can be used, but after what? After cross-examination. So this was about section number 32. Moving on, question number 15. In which of the following cases the evidence given by the witness will not be relevant under section 33 of the Indian Evidence Act 1872? So the answer to this question is A, when the witness is staying abroad. Relevancy of certain evidence of proving in subsequent proceedings the truth of the facts therein stated. Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it is relevant for the purpose of proving in a subsequent judicial proceeding. So a statement made by a person, it can be used in a subsequent judicial proceeding or in a later stage of the same judicial proceeding, the truth of the fact which it states when the witness is dead, or cannot be found, or incapable of giving evidence, or is kept out of the way by the adverse party. This was not mentioned in section 32, but this is mentioned here. If he is kept out of the way by the adverse party, it can be due to coercion, it can be due to force, right? So if he is kept out of the way by the adverse party, or his presence cannot be obtained without an amount of delay or expense, which under the circumstances of the case the court considers unreasonable. So a person who has made a statement in a case, his statement can be used in the same proceedings and a later stage, or it can also be used in what? It can also be used in another judicial proceeding, but there is a proviso: provided that the proceedings was between the same parties, the proceedings, they should be between the same parties or their representatives in interest, that the adverse party in the first proceeding had the right and opportunity to cross-examine, that the question in issue were substantially the same in the first as in the second proceeding. So this is the proviso. It states that the parties should be the same. The question in issue, it should be substantially the same. In that case, they can be used in a later stage, or it can be used in a subsequent proceeding. But if the adverse party had the opportunity and the right to cross-examine that person, they are not saying that they actually cross-examined him, but they had the right, the law provided with that right, and they also had the opportunity. It may be that they did not avail that opportunity when it was given to them, but if they were given that opportunity, in that case it will be deemed what? It will be deemed that they had the right, they had the opportunity, and now that statement, it can be used against them in another judicial proceeding or in the same proceeding at a later stage, right? For example, if we say that there is a person, he is 99 years old, he is very old, he makes a statement in a judicial proceeding, and the adverse party, the judge asks him that I am giving you this opportunity that you can now do what? You can cross-examine them. But the advocate of that party, he pleads some time that I am not prepared today, grant me 4 days so that I can prepare, and then I will do what? I will cross-examine this person. And in between these 4 days, if that person who made the statement, he dies, in that case it will be deemed that the adverse party had the right, and at the same time they were given the opportunity, and that is why the statement made by that 99-year-old person, that is going to be used against them, that can be used against them in the same proceeding or in a different proceeding. Explanation: a criminal trial or inquiry shall be deemed to be proceeding between the prosecutor and the accused within the meaning of this section. So just because the names of the parties are different, because for example in criminal law it is state versus A, and in a civil suit it is A versus B. So only because of the different title, it is not going to be regarded as a different suit, it is going to be regarded as the same case. So that is why the statements can be used here also, right? So a criminal trial or inquiry shall be deemed to be a proceeding between the prosecutor and the accused within the meaning of this section. So they also will be included here. Now question for achievers. Which of the following persons are considered as experts as per section 45 of the Indian Evidence Act 1872? A, B, C, D, E. Person skilled in science or art, person skilled in identifying handwriting, person skilled in identifying finger impressions, person skilled in foreign law. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.